And a bill passed this legislative session meant to protect the privacy rights of citizens, but it may be inadvertently helping fugitives escape from law enforcement. ABC4's Brittany Johnson has been looking into this and joins us live in the studio with the details tonight.
Well, Emily, this is House Bill 57, and state lawmakers passed this to protect the privacy rights of Utahns. HB 57 does require law enforcement officers to obtain a search warrant to access your private information stored on third-party devices. But it also alerts wanted fugitives that law enforcement is looking for them.
Police U.S. Marshals with a warrant. Come to the door, man. We have the house surrounded.
Fugitives in Utah. Since 2016, the United States Marshals Service has arrested nearly 3,000 of them. 95% are violent criminals wanted for murder, rape, child sexual exploitation, and aggravated assault.
We're fugitive hunters. That's what we do. That's what we do well. That's what we're known for.
But a bill passed this legislative session could inadvertently help these violent fugitives evade capture. House Bill 57, Electronic Information or Data Privacy, requires law enforcement to obtain a warrant to access stored electronic data, including information on personal devices stored with third parties. The men and women who track down these violent criminals are feeling the impact of this new law.
We don't necessarily comment on state law, but the majority of our work, 65 to 70% of the violent fugitives that we catch, are state and local warrants. So anytime there's a change, it does affect our operations.
Warrants allow officers to engage in activities that could violate an individual's constitutional rights. Under HB 57, once a warrant is secured by a law enforcement agency, the person who is the subject of the warrant is notified. U.S. Marshal Matt Harris says the notification requirement when it comes to fugitives is concerning.
Looking for violent criminal fugitives, do they really need to know when they're on the run how we're looking for them? I don't think so. We want to go after the fugitive when they least expect it, when they think they're safe. And that's what we prefer. It's the most safe way to do it, it's the most intelligent way to do it, and it's the most practical way to do it.
The law does allow for an extension. Officers must petition the court to delay notification to the fugitive. Representative Craig Hall is the bill's sponsor.
We're not saying that law enforcement shouldn't have access to that information. We're just saying that if law enforcement sees a good reason why they need access to that information, they go before a judge, a neutral third party, and have the judge sign off on a warrant before they get that information.
But any time that I got to take people off the street and put them inside a building, that's less fugitives that we're catching.
Agent Harris believes a notification should only be required after the fugitive is apprehended and in custody.
During the court process, through the Fourth and Fifth Amendment, I mean the defendant or the fugitive have the right to know the charges brought before them. That's an opportunity to provide the fugitive information of how their data or information was obtained.
Representative Hall says he's worked with law enforcement extensively since 2018 to come up with the perfect bill. I asked him if impact on fugitive investigations were taken into account.
This bill has been out in the open for over 2 years. We included anybody who raised their hand and said that they wanted some input in the bill, and law enforcement communicated to the legislature that they were fine with the bill. They gave it a thumbs up, and that's why the bill passed unanimously.
But still, Harris says U.S. Marshals are left feeling the brunt.
No bill is perfect, and if another organization or entity or individuals want to help make the bill better, we are all ears, and we are open to suggestions on how we can make the bill better.
So marshals agree to access an everyday person's information. They should have a search warrant. But again, for violent fugitives, they want to be able to go after them. Then after they're caught, provide all the search warrant information, letting them know exactly how agents were able to track them down and what personal information of theirs was accessed.
All right, Brittany, so this poses the question, what is or is there a disconnect between these federal agents and the bill sponsor?
So I don't really think there's a disconnect. It's just
there's a misunderstanding here. The federal agents can't comment on state laws because that's a Department of Justice rule. They just can't comment on that. They have to be asked and invited by lawmakers for their insight on these state laws. So if they're not invited, they don't provide their input.
Right.
But as you heard there, the representative saying he's willing, he's all ears, willing to listen for their input to make changes if needed.
All right, an ongoing story. Thank you so much for that, Brittany.
All right, no problem.